Hello guys, welcome back to my channel. It's your favorite lawyer again. So today we'll be continuing with our family law series, and we have already done 3 parts in the 6-part series. You'll recall that the first part was prenuptial agreements. The second part was on court marriages, properly so-called statutory marriages. That's the proper name. While the third part was on divorce proceedings, divorce in Nigeria. Then this fourth part we'll be looking at today is something closely related to divorce proceedings. And the topic for today is separation in marriages. So we'll start by establishing that the concept of separation in marriages is properly known as judicial separation in Nigeria. It's also referred to as legal separation. And the reason is not far-fetched because it is a form of separation that is given by the court. The first thing we note about separation, as the name implies, is that a couple are being separated from a union. We will note first that separation is different from a divorce. They are two distinct terms, and that is why we are looking at them separately. So separation does not end the marriage. Only a divorce can end the marriage. Now we'll go into the 2 types of separation. The first type of separation is the informal separation, whereby a couple just live apart informally. Judiciary is not involved and they just decide to live apart. They don't stay together as a couple. There's no formality in this. It could also involve their families, but the courts are not involved in this process. The second type of separation in a marriage is the judicial separation, which is court ordered. So you can call it the court ordered separation, or the judicial separation, or legal separation. And so the judicial separation is court ordered, and it enables the court to intervene with respect to the separation of both parties, but yet determine issues that relate to the management of their finances as a couple, even though they are now separate. So judicial separation will cater for issues with respect to management of their finances, the custody of the children in the marriage, and the arrangement with respect to the family property. So this is what judicial separation entails, which is unlike the informal separation that the parties just make the agreement on their own. Now we'll go into the grounds upon which a party can go to court to request for an application for judicial separation. It is important to note that the principal law that governs separation in statutory marriages in Nigeria is the Matrimonial Causes Act, which we also saw in the video on divorce proceedings. So it's the same Matrimonial Causes Act that applies to divorce proceedings that also provides for the concept of judicial separation. And the Matrimonial Causes Act, we can refer to it in this video as MCA. Now, the Matrimonial Causes Act, just like it provided for the grounds and factors upon which one can bring a petition for a divorce proceeding in Nigeria, the same grounds are applicable when one wants to apply for an order of judicial separation. And so the MCA in section 39 provides that a party that wants to make an application for an order of judicial separation should have to base its application on any of the grounds or factors that were stated in section 15 of the MCA, which are the same grounds and factors that have to be in consideration before one can make a petition for a divorce proceedings. So to not be repetitive, I would like to refer you to the previous video on divorce proceedings because the factors are the same, but I'll just summarily state them in this video so that we can have some coherence in understanding in the course of this video. And by the way, petitioner is the party that is instituting the action in court, while the other party is the respondent. That is with respect to proceedings under the Matrimonial Causes Act. So either a man or a woman could be the petitioner, while the other spouse will be the respondent. So the first factor upon which a petitioner can base his or her application for an order for judicial separation is the fact that the respondent has refused persistently and consistently to consummate the marriage. It's a factor upon which the petitioner can approach the court, and in this instance is the High Court of a state in Nigeria or the Federal Capital Territory. The petitioner can approach the High Court and request for an order of judicial separation. The second factor upon which a petitioner can approach the court for this decree of judicial separation is the fact that the respondent has committed adultery and the petitioner finds it intolerable to continue to live with the respondent. At this point, it is important to note that if the petitioner can condone it or can tolerate it and forgive the respondent, then there is no issue. But if the petitioner finds it disturbing, it can be a fact and the ground upon which the petitioner can apply for a decree of judicial separation. Also, it is important to note that if the petitioner forgave the respondent at some point, but however subsequently feels it can no longer condone the respondent's action, it can also still be a ground as long as the petitioner can establish that it is disturbing to him or her and he or she can no longer tolerate that act of the respondent. The third factor upon which a petition for a decree of judicial separation can be brought is that the respondent has behaved in a manner in which the petitioner cannot tolerate. On this particular ground, the petitioner finds it intolerable and that he cannot be expected to reasonably live with the respondent. And that's why the petitioner seeks for a decree of judicial separation. So, under this particular ground, the type of behaviors of the respondents which the courts will consider are instances of violence, habitual drunkenness for a long period of time. Another example is if the respondent has been involved in acts like bestiality or rape or sodomy. Any of these sexually related offenses constitutes intolerable behavior that the courts will consider if the petitioner brings a petition based on this kind of acts. Another instance is where the respondent is of unsound mind and the petitioner cannot tolerate that act of the respondent because of the respondent's state of mind. The important thing is that the petitioner believes that he or she is unable to expectedly live with the respondent in that kind of situation. The fourth factor upon which a petition for judicial separation can be made is that the respondent has deserted the petitioner for a period of 1 year. And another factor is that the parties have lived apart for a period of 2 years. If it's for 2 years, the consent of the respondent will have to be sought. But if it's for a period of 3 years, the consent of the respondent is not required. Now, this leads us to the next subtopic, which is the effects or the implications of this order of judicial separation. So, kicking off from the last factor upon which the petition for a decree of judicial separation can be made, I stated that if the parties have lived apart informally, they can now request for this formal judicial separation. And the question is, why do you now need the judicial separation if you have already lived apart? This even now further highlights the importance and the implications of the judicial separation. The first implication or effect of a judicial separation is the fact that it gives the parties relief from that duty to cohabit. Now, it is expected that what makes a couple is the fact that they cohabit. That means they live together. But this obligation to cohabit is removed or suspended whilst the decree of a judicial separation is in force. So that means that as long as the parties have gotten an order or a decree for judicial separation, they are relieved from that duty to cohabit. Now, you will recall that when the parties are not cohabiting, when they are living apart, it is a ground upon which a petition for judicial separation can be brought or a petition for dissolution of a marriage can be brought. But if the parties now obtain a decree of judicial separation, then they are free from that obligation to cohabit in the meantime during the pendency of that decree of judicial separation. The second implication now of the judicial separation is that it entitles the parties to sue one another in contract or in tort, TORT. This is because once the couple are a couple without the judicial separation, they cannot sue themselves in contract or in tort. But one of the effects of the order of judicial separation is that it relieves the parties from that immunity by which they cannot sue themselves in contract or in tort. So during the pendency of a decree of judicial separation, the parties have a right to sue themselves. Either of the spouses can sue the other party in contract or in tort. The third effect or legal implication of judicial separation is that if one of the parties dies during the subsistence of the order of judicial separation, if the party dies intestate, that is without a will, the property will devolve to the surviving party, irrespective of the fact that the order of judicial separation is still pending before the death of the party that has died intestate. So this means that even if a party dies during the subsistence of an order of judicial separation, and if he dies intestate, he doesn't disinherit the other party. So the surviving spouse will still inherit from the late spouse that died intestate. Now, note that all these provisions are contained in Section 41 and Section 42 of the MCA. So, like I said earlier, judicial separation is a concept that has been provided by that act, by the MCA. And so, everything pertaining to judicial separation is contained in the MCA. The fourth implication of a judicial separation is the joint powers of the spouses, particularly the wife. Now, this implication is that a wife retains the ability to exercise all the powers that her husband had conferred on her prior to when the order of judicial separation was granted. So, Section 43 of the MCA states that nothing affects the abilities of a wife to exercise all the powers and authorities that her husband has given her before the order of the judicial separation was granted. The fifth implication or effect of a judicial separation is the fact that you cannot remarry during the pendency of a decree of judicial separation. Now, this is important because, as I stated earlier, a decree of judicial separation is different from a decree of dissolution of a marriage. So this means that a decree of judicial separation does not put an end to the marriage. It does not dissolve the marriage. It doesn't mean that the couples have been divorced. If the marriage has not been dissolved, the parties are still married. They cannot legally get married again until they properly dissolve the marriage. This part is very important because it boils down to the concept of separation being different from a dissolution of a marriage. So the question now is, why separation? What is the essence? Why do you need separation? And the first and important reason why judicial separation is important is that it gives the parties time to deliberate over their marriage and see if they can reconcile their differences and get back to being a couple once again. So in the same way, it also gives the parties time to decide whether they want to go ahead with a full divorce rather than just a separation. Another benefit of taking the route of judicial separation is where the parties consider their religious beliefs or cultural beliefs sacrosanct and those beliefs are against divorce. So taking the route of judicial separation is important because in the course of determining the petition for judicial separation, the courts will consider issue of property of the couple, the finances of the couple, and the custody of the children and their maintenance. So the parties may feel that as long as the courts will make orders based on these factors, then they don't really want to go into divorce based on their religious or cultural beliefs. So now we'll talk about the bars or barriers with respect to judicial separation in Nigeria. And basically, the main barrier that can affect one's petition with respect to a decree of judicial separation is condonation. Condonation means that the petitioner condoned that act of the respondent. If the respondent can establish that the petitioner condoned the act, his or her act, then it can be a barrier. It can affect the petition before the court. However, like I mentioned earlier in the video, if the petitioner can still prove that irrespective of the fact that he or she condoned the respondent's act, he or she as the petitioner can no longer tolerate that act. So the court should grant that order for judicial separation based on the fact that the petitioner can no longer tolerate that act of the respondent. The second bar or barrier is connivance or collusion. Connivance or collusion is that the petitioner colluded or joined the respondent to do that act upon which the petitioner has now brought that petition for the judicial separation. Now, this is clear because if the petitioner was involved and material to assisting the respondent do that act upon which this petition is brought, the petitioner cannot be made to benefit from, on one hand, from what he or she had assisted the respondent to do. So it is clear that if the petitioner was involved in any way and assisted the respondent in any way to do that particular act, then it means that the petitioner cannot, based on that same factor, bring a petition for the judicial separation to be made. So basically, these are the main barriers that can hinder or affect one's petition for an order of judicial separation. So in conclusion, let's note that judicial separation can be a useful step for couples that are in difficult marriages. It gives the couple some time to reflect and think of their choices, whether they want to continue with the marriage or whether they want to end the marriage through divorce proceedings. Meanwhile, while it gives the couple this type of time, it also caters for pertinent issues with respect to maintenance of the children, the welfare of the children, their custody, and with respect to an arrangement of finances and properties in the marriage. We will also note at this point that if the couple decide to continue with the marriage, they can go back to the court and request that the court should set aside that order of the decree of the judicial separation. So that is the legal way to terminate the order if it has been granted. Or if the couple don't want that option, they can also go through the path of divorce if that's what they want, or if they want to just let it remain as judicial separation while they remain legally married with their rights as married couple. So this is where I'll be doing the cutting in this video, and I would like to get your comments or reactions, if any, in the comment section below. Also, please do well to like the video as always, and please subscribe to the channel so that you get notifications of newer videos as they are uploaded. I'll see you in my next video. Bye.